Hello and welcome. I am happy to have you here. For those of you who are joining us, today we're going to talk about things that you should never ask when you're hiring an employee. If you've gotten to this point in your business, you're excited and you want to bring that new person on, these are some things that can get you in trouble legally. So we're going to talk about those in just a second. Before we begin, I'd like to introduce myself. My name is Taylor Darcy. I am a California licensed attorney with Think Legal, and I help you create the business of your dreams, whatever that may be. I go live every weekday at 11 a.m. In order to answer questions and to hang out and just give you tips and things that you need as a business owner, how to get started in the right way. So welcome. I'm very excited to have you here today, and I look forward to, if you have any questions, please leave them in the comments, and let's get started. So these are things that can get you in trouble legally and that can end up with a discrimination suit or other types of things that will hurt your business. And so it's just best to stay away from them. I understand that there may be some desire to get to know your potential employees, but what you don't want to have happen is someone come back and say, well, they didn't hire me because of this. And then you get embroiled in a lawsuit, an unnecessary lawsuit, because you asked a question that you shouldn't have asked. So you want to stay away from questions that related to age, gender, race, that type of thing. So you want to stay away from recent graduate or energetic person or digital native in your job postings. Is because otherwise what can happen is that can be inferred for ageism or that type of thing. You want to avoid a single source for your potential applicants. And the reason for this is that, for instance, word of mouth, although might yield you a solid candidate, the problem is that if you're the majority of the people that are a particular race, then it could be seen as discriminatory against people of different races if you are hiring only by word of mouth. So you really want to put a broad scope out there. And you have to also be careful the words you choose. So for instance, if you have an automated program and you're looking for keywords in a resume, you want to make sure that those words that you're looking for are non-discriminatory or could not be inferred differently, because they could also set you up for a potential lawsuit if someone isn't fairly considered based upon that. The next thing that you want to avoid, please, if you're following along, please leave in the chat any questions you might have, and I'll get to answering them. Don't background check until after the applicant pool has been narrowed or you're down to a single candidate. This eliminates the possibility that you would use that as something of a discriminatory nature, that you've hired them based upon the merits of the applicant and not based upon a potential background issue. Now, that being said, if you do find something in their background that makes it not optimal for your position, then you haven't extended an employment, you haven't extended an offer yet, so you could move on to the next. So you want to do this fairly late in the process, but not too late, so that you give up good applicants that might not have that same issue that you're looking for. The other thing that you want to avoid is extending a verbal offer for employment. This is something that can get you in trouble. You want to make sure that you're extending a letter outlining the details of it and ensuring that the person understands that it's an at-will position. You want to avoid anything that could be misconstrued as any type of contract, any type of agreement, especially if it's at will. Now, if you are doing a contract, then sure, absolutely. But the purpose of at-will employment is that you don't have to have a reason to fire someone. You can just let them go. You don't have to worry about the contract. So there's issues that go with any type of implication that anybody is anything other than an at-will employee. And that brings me to the next point. You want to stay away from, if you're a non-union position, or if there's no union involved, you don't want to have anywhere implied that the 90-day probationary period exists, 90, 180 days, because a true at-will employee is technically always on probation. You want to avoid saying that if you put a 90-day probation, then people could infer that after 90 days they can only get let go for cause. And so you want to avoid that by just maintaining at will at all times. If you don't have an employee handbook, before you get an employee is the best time to get an employee handbook. And you want to make sure that throughout that, in everything that you do, you want to ensure that it's stating unequivocally that it is an at-will employee relationship, and that there is no contract, and that no contract can be inferred by actions or words of either party. That the only time a contract could exist is if there's actually a contract in writing, signed and executed by both parties. By eliminating the potential for them to misconstrue an act, or a statement of a good job, or we couldn't have done this without you, and you have a job here for the rest of until you don't want to be here, because you're trying to reassure them and give them positive upbringing, or not upbringing, positive reinforcement for a job well done. You want to make sure that it's clear, it's oftenly, wow. It is stated often that it is an at-will relationship, and that nothing by contact or orally, other than writing, should infer anything other than an at-will relationship. And you should have that not only throughout any type of contract negotiation, non-contract negotiation, but when you're discussing terms of the job, salary, vacation, all of these things should be memorialized in writing, with the specific details of each, to make sure that each party understands it, and make sure that there's that each party knows that it's truly at will, and that there's technically no probationary period, because the whole time they're employed is a probationary period. That 90 days doesn't mean that after that they can. That really sums up the things that you want to avoid when you're hiring. There are lots more, but those are the top big ones that can get you in trouble in any type of relationship. So you really want to stay away from those. If you've gotten value out of this video, please don't forget to subscribe and like. I'm here to help you, and I hope you have a great week, and we'll talk to you later.